Foreclosures Section 6, Court-Ordered Sales, actions in which orders for sale may be made. Sales of property by court order can be for reasons other than foreclosure. The following list, though not exhaustive, describes actions in which the court orders the sale of the property. Matrimonial actions, for example, divorce, division of property, etc. Estate actions such as wills variation, incapacity, committeeship, partition and sale actions, and builders liens actions. Most of what we examine in this course is with respect to foreclosures. A realtor should be aware that a listing they may be given could be the subject of a court action, whatever the type. An order might be made for the sale of the property such that the realtor's listing agreement may be superseded and legally unenforceable. Foreclosure actions. In most foreclosure actions, at some point, an order for conduct of sale will be pronounced. This order allows the lender the legal and exclusive ability to list the property for sale using a realtor of the lender's choice, with the listing commencing at a certain date. The order will also usually state that the court must approve the sale unless all parties agree to it. Most lawyers will apply for the order approving the sale because in the process members of the public are allowed an opportunity to submit bids. On rare occasions, all parties will reach an agreement with respect to a sale, and the court application is thereby avoided. Such an arrangement should be carried through carefully, because even if all the parties agree to a sale, it may not be at the best quote-unquote price, and marketing might yield a higher price. Once the order for conduct of sale is pronounced, the lender will list the property. Marketing will proceed in much the same way it tends to in non-foreclosure situations. However, when an offer is received, the listing realtor will pass it to the lender's representative, who will at some point agree to bring the offer to court for its consideration. Different parties may make offers in foreclosure actions, but only one will be brought forward to that court for consideration. The lender will choose which one will be brought forward. However, that does not mean the unsuccessful offeror has to abandon their efforts to make an offer or otherwise purchase the property. An offeror whose offer is not brought to court by the lender may still attend the hearing of the application for the order approving sale. That offeror will be given an opportunity to present a bid to the court. This situation is known as the multiple bid situation. Any interested party may attend court for the hearing of the application for the order approving sale. There is a procedure generally followed in court to handle multiple parties. Typically, the listing realtor will attend court in a multiple bid situation. The realtor will find all of the interested parties in the courtroom prior to the court convening. The lender's lawyer will arrive in court, and the listing realtor will then gather all of the parties, and those parties will meet with the lender's lawyer outside the courtroom. The lawyer will explain the full circumstances of the bidding system to them. What is paramount is that each party must be given an opportunity to make a bid. The lawyer will permit each party to sit with their selling realtor and discuss what bid they are prepared to make. Eventually, the parties bidding will reach a decision on their purchase price, closing date, etc., and will complete a contract of purchase and sale. When each interested individual completes their offer on a standard contract form, it is placed in a sealed envelope along with a draft for their deposit. The original bidding party is also given an opportunity to present a new bid. When all the sealed envelopes are collected by the listing realtor, that realtor will alert the lender's lawyer They will then ask for the case to be called in court, and the application is eventually heard. Master's procedures. The vast majority of foreclosure applications are heard by masters rather than judges. Masters have limited authority in certain areas of law, and their authority extends to foreclosure cases. For all intents and purposes, masters are judges, and there's no need to be concerned as to their authority to make orders in foreclosure cases. Masters hearing applications for orders approving sale will be given the envelopes prepared by the bidders. Typically, masters will, before opening the envelopes, ask in open court whether there are any further individuals interested in making a bid. The master will provide the property address. If no new party comes forward with a bid, the master will then open the envelopes and read out the bids, or depending on the master, will simply read out the bid he or she chooses to approve. Normally, the successful bidder will be the one who bids the highest price. Masters can only approve subject-free offers. If subject to financing clause in a contract cannot be approved, a subject to financing clause in a contract cannot be approved. This is because the master cannot approve an offer that may not be able to complete. Once the master has chosen the successful contract, the lender's lawyer will be asked to approve the document. He or she will not have seen it in advance for convincing purposes. In other words, the lawyer has to make sure the contract is in proper form so as to constitute a proper offer. What the lawyer looks for is whether the appropriate clauses are deleted and the peripheral documents are included. A foreclosure attaches only the property and all of the fixtures on it. Therefore, the clause, presently clause 7, dealing with what is included in the offer must be deleted. This clause covers such things as curtains, appurtenances, and so on. This cannot be part of an offer in a foreclosure, and so that clause must be deleted. Similarly, the clause, presently clause 8, that says that the property will be in substantially the same form as when it was viewed on some previous date, must be deleted. In a foreclosure, one cannot guarantee property will in fact be in the same condition a month or two after it was viewed. A property in a foreclosure action is purchased as is where is, and as such the buyer takes what he or she gets when they actually move in on the possession date. Therefore, that clause must be deleted. There must also be included in the offer what is known now as the Schedule A. Some lawyers also include a purchaser information sheet. These will be expanded on later in the workbook, but briefly the documents are as follows. Schedule A is a document that contains a clause confirming that the lender's obligations in the foreclosure selling process is limited to bringing an offer before the court for consideration. The lender cannot accept an offer as a seller does in a non-foreclosure sale of property. The court accepts the offer by approving the sale. The purchaser information sheet is really designed to clarify the identity of the buyers. The document provides the buyer's full name, their occupations, and whether they're taking the title as joint tenants or tenants in common. Also disclosed on the document is the name of the lawyer or notary acting for the buyers. The latter information is handy for the lender's lawyer. After the hearing of the application for order approving sale, it is useful for the lender's lawyer to know with whom he or she will need to communicate in order to facilitate the sale transaction. Supreme Court rules. On July 1st, 2010, the Supreme Court rules came into force, fully replacing the old rules. The old foreclosure Rule 50 has been replaced with Rule 21.7. Rule 21.7 is substantially the same rule dealing with foreclosures and cancellation. Similarly, Rule 51A, which described how to bring an application, has been replaced by Rule 8.1, which is again quite similar, although the time calculation is new. It now takes a little longer to bring most types of applications in foreclosure cases. However, according to Rule 8.5, rush or urgent applications may still be brought on quicker. The object of the Supreme Court rules in this area is to encourage persons in foreclosure actions to file responses to applications. This will help reduce court time and reduce the probability that respondents will ask for adjournments in application hearings. The problem is that sometimes individuals appear in court without having filed any response documents. In such situations, the courts will be generally reluctant to grant adjournments given the preparation the lender's lawyer will have made and the opportunity the respondent will have had to file a response or otherwise communicate with the lenders or the lender's lawyer. For realtors, it helps in general because it removes some of the uncertainty in the foreclosure process. It is less likely that an application will be adjourned these days, given the structure of the rules. It is more predictable, for example, that a conduct of sale order will be made on the chosen hearing date, unless, of course, response material is filed such that the lender knows in advance that there will be opposition. The realtor will be better able to plan his or her schedule. Order made after application. An order made after application is an order that approves the sale of a property and is used when there has been a buyer found for the property. The lender has no ability to complete the sale without a court order. For this reason, the lender should make its acceptance of the offer expressly conditional on approval by the court. An order made after application approves the sale of the property to the buyer on the terms of the contract of purchase and sale, applies title to the buyer for land title registration purposes, provides for vacant possession to the buyer on completion of the sale, fixes the priorities for distribution of the sale proceeds, and authorizes the disbursement of the sale proceeds, clears title of the parties' encumbrances, and allows the parties to return to court for further relief if necessary to carry out the sale. An order made after application should be brought by notice of motion and a supporting affidavit. The affidavit should be sworn and will provide the following evidence: that the mortgage debt remains unpaid, the appraised value of the property, an outline of what steps were taken to list the property for sale during the course of the listing, and information about other offers received but either rejected or not made unconditional by the prospective buyer. The affidavit should have attached as an appendix a current independent appraisal of the property. Name of the buyer. Realtors bringing offers on foreclosures often add to the name of the buyer. Some land title offices in BC will not accept for registration an order made after application applying title to a named buyer. For this reason, the buyer's identity should be ascertained early on, preferably before the acceptance of the offer, to ensure that the order made after application does not contain those words. Moreover, there is an argument that a contract of purchase and sale using these words will be void for uncertainty. Who can apply? Any party to a foreclosure can apply for an order to prove the sale. The lender's lawyer usually applies for an order made after application when there is an offer on the property. Property transfer tax responsibility under an order made after application. An order made after application is different from an order absolute, in that the new buyer will be responsible for the property transfer tax, not the lender. Order absolute. When the redemption period is expired, the lender will make an application by way of a notice of motion and give 2 clear days notice to all parties involved for an order that it become the registered owner of the property, free and clear of any charges registered against the title to the land. This order is called an order absolute, and once it is obtained, it prevents the lender from purchasing the borrower for the judgment amount. There will be an order for court costs, usually to the lender, but the order absolute extinguishes the debt under the loan agreement. The purpose of an order absolute of foreclosure is to transfer the title to the property to the lender and cancel any subsequent charges on title. An order absolute is usually sought either after the redemption period expires or at the hearing of the petition in lieu of an ordinancy of foreclosure where there is no equity in the property, and the lender does not wish to pursue the borrower on a mortgage covenant for judgment. The order absolute is registered in the land title office instead of a Form A transfer. Who pays the commission? When acting for the owner of the house, if there is not enough equity in the property, the realtor may not get paid at all. The registered charge holders who are on the title of the property come first. But when a foreclosure action has started, the lawyer or the lender will apply to the court for the approval of the sale. In this document, it will say that the realtor will be paid and describe what the commission will be. The commission is then added to the costs of the foreclosure proceedings and is accounted for by the courts. The realtor will receive payment in top priority, just the same as any other transaction from the lawyer, although municipal taxes are paid out first from the proceeds of the sale. See payment order on page 22. Under an order absolute, no commission is paid because the title is simply being transferred into the lender's name. Risks for the bank. Contaminated sites. The lender on every foreclosure must consider any potential for environmental problems such as an underground oil storage tank. A mortgagee, upon a transfer of property by order absolute, may be responsible for remediation of the property if it is a contaminated site. Section 45. 1. Subject to Section 45, person not responsible for remediation. The following persons are responsible for remediation of a contaminated site. 3. A secured creditor is responsible for remediation of a contaminated site if B. The secured creditor becomes the registered owner in fee simple of the real property at the contaminated site. However, pursuant to Section 45 of the Environmental Management Act, a mortgagee's liability is limited by the length of time it owns the property. Persons responsible for remediation of contaminated sites. Section 45. 1. Subject to Section 45, persons not responsible for remediation. The following persons are responsible for remediation of a contaminated site. A. The current owner or operator of the site. B. A previous owner or operator of the site. C. A person who, Roman numeral 1, produced the substance, and Roman numeral 2, by contract agreement or otherwise caused the substance to be disposed of, handled, or treated in a manner that in whole or in part caused the site to become a contaminated site. D. A person who, Roman numeral 1, transported or arranged for transport of a substance, and Roman numeral 2, by contract agreement or otherwise caused the substance to be disposed of, handled, or treated in a manner that in whole or in part caused the site to become a contaminated site. E. A person who is in a class designated in the regulations as responsible for remediation. 2. In addition to the persons referred to in subsection 1, the following persons are responsible for remediation of a contaminated site that was contaminated by migration of a substance to the contaminated site. A current owner or operator of the site from which the substance migrated. B, a previous owner or operator of the site from which the substance migrated. C, a person who, Roman numeral 1, produced the substance, and Roman numeral 2, by contract agreement or otherwise, caused the substance to be disposed of, handled, or treated in a manner that, in whole or in part, caused the substance to migrate to the contaminated site. D, a person who, Roman numeral 1, transported or arranged for transport of the substance, and Roman numeral 2, by contract agreement or otherwise, caused the substance to be disposed of, handled, or treated in a manner that, in whole or in part, caused the substance to migrate to the contaminated site. 3. A secured creditor is responsible for remediation of a contaminated site if A, the secured creditor at any time exercised control over or imposed requirements on any person regarding the manner of treatment, disposal, or handling of a substance, and the control or requirements, or in whole or in part, cause the site to become a contaminated site. Or B, the secured creditor becomes the registered owner in fee simple of the real property at the contaminated site. 4. A secured creditor is not responsible for remediation if it acts primarily to protect its security interest, including without limitation, if the secured creditor A participates only in purely financial matters related to the site. B, has the capacity or ability to influence any operation at the contaminated site in a manner that would have the effect of causing or increasing contamination, but does not exercise that capacity or ability in such a manner as to cause or increase contamination. C, imposes requirements on any person if the requirements do not have a reasonable probability of causing or increasing contamination at the site. Or D, appoints a person to inspect or investigate a contaminated site to determine future steps or actions that the secured creditor might take. A Phase 1 study can be done at a cost of approximately $1,500, $1,500. This consists of a site inspection and historical review of the use of the property. Under current environmental legislation, taking possession of environmentally contaminated property could incur direct liability for environmental contamination which exists or occurs during their possession. Taxes under an order absolute. Who pays? The property transfer tax is payable by the lender as the new registered owner under a transfer by order absolute, unless the mortgagee was the immediately preceding registered owner of the land. Definitions and interpretation. Section 1. 1. Taxable transaction means a transaction A purporting to transfer, grant by any method including a disposition, an order of a court including an order absolute of foreclosure, or by the operation of any enactment or law. Tax imposed. Section 2. 1. Subject to subsection 2 on application for registration of a taxable transaction at the Land Title Office, the transferee must A. pay tax to the government in accordance with Section 3 or 38, and B. file a return in the prescribed manner whether or not the taxable transaction is exempt under this Act. Exemption. Section 14. 3. If a taxable transaction entitles the transferee on compliance with the Land Title Act to registration in the Land Title Office, that transferee is exempt from the payment of tax if the taxable transaction is a transfer within any of the following descriptions. Section 14.4. If a taxable transaction entitles the transferee on compliance with the Land Title Act to registration in the Land Title Office, that transferee is exempt from the payment of tax if the taxable transaction is a transfer within any of the following descriptions. M. A transfer to a mortgagee if the mortgagee was the immediately preceding registered owner of the land. What about the shortfall? Mortgages in Canada may be insured, depending on the circumstances of the buyers. In Canada, there are three main providers of insurance for high-ratio mortgages: Canada Mortgage and Housing Corporation, CMHC, Genworth Financial Corporation, and Canada Guarantee. That means they provide insurance for the lender. The buyer will be dealing with a lender, being either a bank, credit union, or trust company. The insurers will act with the lender to insure a mortgage that is called high ratio or higher than what the lender will lend under its policies and legal requirements. A high ratio borrower typically borrows roughly 95% of the purchase price amount. The buyers will then execute specific documents when they sign the loan documents at the bank. The extra documents pertain to the insurer. There is an insurance fee, which usually is a percentage of the loan amount. If the property is later the subject of a foreclosure action, then what will happen is this: the conduct of sale order is eventually made, and then the property is listed. If after a certain period of time, normally 90 to 120 days, the property remains unsold, the insurer will take title to the property. The insurer pays the mortgage lender the amount of its mortgage. The lender then assigns its judgment obtained at the ordinancy hearing to the insurer. Then the insurer will try on its own to sell the property using realtors that the insurer typically works with. The insurers of this sort will periodically tender their business to the real estate profession. Realtors who wish to do this kind of work bid on it, usually involving commissions that are less than regular market commission rates. Realtors who list insured property at the outset, acting for the lender, will have to work perhaps more intensely than normal given the deadline these mortgages carry with them. And that's the end of section